Welcome to the Law, Your Money, and You. I'm Roberta Saphire, an attorney in Sharon, Massachusetts.
And I'm Camille Barron, a financial coordinator also in Sharon, Massachusetts. And today, Roberta, we have one of our favorite people back on the show by popular demand. And this person is an expert on employment law.
She's also the chairperson of the Law, Your Money, and You Advisory Board. And she has written a book which is so important in today's world on employment laws. Welcome, welcome, welcome. Welcome, Emily Smith-Lee.
Thank you very much. It's great to be back.
Let's go right into it. I mean, everybody knows you're a brilliant attorney and all that, but you wrote this book, Rules of the Road, which she's not selling. It's free.
That's right.
And it's so good. It's so good.
Thank you.
I went through it and looking for things that might be wrong, and there's nothing. It's so easy to read, and it's so informative. And you didn't need this years ago, but you need it today.
That's
so
right.
tell us what prompted you to do this.
So it's a little book, so that's not everything we know, which would be a much bigger book, but it's a little on purpose for exactly what you said, so that people can read it, understand it, digest the information. I wrote it because over the years, there's a handful of things that either my clients or the people my clients have sued wish they'd known, and could have saved them a lot of time, could have saved them a lot of money. So this is meant to be really kind of a dummy's guide, a cheater's guide to some of the easiest ways for employers to get into trouble.
And this is written for both employers and employees, right, Emily?
That's right.
Oh, good point.
We work with both.
Mm-hmm.
You were telling us about the cover.
Oh, yeah. So they designed the cover with this nice, beautiful road. And I said, no, that's too peaceful looking. So they put in this wrong way to the back sign.
That's great.
Oh, yeah, wrong way.
As
like
a warning.
that. Yes.
As a warning.
Funny.
So what are some of the main topics that you've written about, Emily?
So we've covered broadly termination and discipline. And that picks up a lot of things that people don't fully understand. There's a lot of myths out there about needing to provide warnings and written documentation. It's great and super helpful in demonstrating why you terminated somebody.
That's true in other states,
But
but here it's here it's like at will. You don't need a reason. However, if you don't give a reason, can't the employee start saying, "Oh, well, there's still other things." Tell us. About
Absolutely. So actually, maybe then we should start in the last
Yes,
chapter.
we should.
Oh, okay.
Which is called "Just because it's legal doesn't mean it won't get you sued."
I like it.
Oh, that's it.
I cannot tell you how many times we have people who have called us who are very upset about something that was done to them that felt unfair or felt wrong or that they were ambushed. And at the end of the day, that thing that they were upset about wasn't illegal. But if you look hard enough, you'll find a lot of employers have broken other rules, and that's what some of these other chapters are about.
Oh.
People constantly get the overtime exemptions wrong.
Oh,
People
that's right.
constantly get the independent contractor status wrong.
Right.
People, especially out-of-state employers with Massachusetts locations, haven't stopped to read the Wage Act about when they're supposed to pay. Massachusetts minimum wage is much higher than it is in other states. So there's all kinds of ways, and it's the employee who's mad who goes knocking on a lawyer's door. And a decent employment lawyer is going to say, sorry, you don't have a discrimination case, but did you work overtime? Did you?
I see.
So perhaps I should have put the last chapter first.
No, actually, it's in both cases. It's very it's impactful to say the least. Yeah.
Other things that are in here that are covered that are poorly understood, I think, by both employers and employees.
Well, I just opened up on the Massachusetts Earned Sick Time Law. Can you tell us about it? And do you know if that's true in other states?
I don't know if it's true in other states. It's pretty new here. It went into effect in the summer of 2015.
That is good.
And what it does is it requires all employers to accrue sick time for their employees at a rate of an hour for every 30 hours worked. Depending on the size of the employer, you may or may not have to pay for the sick time. But that picks up a lot of people who fell through the cracks on benefits like that because they worked part-time. The really, really new thing about this, though, is that there's an anti-retaliation provision in there. So that if you have an employee who's using their accrued sick time, and they can use it not just for being sick, they can use it to take their kid to the doctor, they can use it to do routine medical appointments, If you're an employer with somebody who's using that time, you can't hold it against them.
Oh, okay.
Part-timers too?
Part-time, they just accrue it more slowly, right? So if you work 10 hours a week, you'll only get your first hour after 3 weeks, but you'll still chip away at that accrual.
You have to give that? I didn't read that.
I think the cutoff for paying for it is 11 people, 11 employees.
Oh.
But it's 11 human beings, not 11 full-time equivalents.
Ah, okay.
Oh, so it could be 11 part-timers?
That's right.
Because I know, isn't there one thing where it's 50, you have to do something
Yes,
with
that's
50?
the Federal Family Medical and Leave Act. And there's a chapter in here about employee illness and disability because it's really confusing. Because you've got the Federal Family Leave Act, only applies to some employers, only applies to some employees. You have to be working for more than a year. And then you have the State Earned Sick Time Act, which is a little broader.
So which one supersedes the other?
They can coexist.
Oh.
They can coexist because under the FMLA, you have to provide 12 weeks of job guaranteed leave. You don't have to pay for it, but you have to give the person their job back.
So if somebody has a paternity leave, like our show's in Boston now, and the fellow called me back, he says, oh, I was away on paternity leave.
Yep.
Yeah.
Yep. I think birth or adoption of a child is part of the FMLA.
Taking care of
Criteria.
sick parents, sick spouse, something
Right.
like that. Okay. So they can't fill your job with somebody else.
Right.
Yeah, but
Unless
what,
it's more
what do
than
you
12
do with an
weeks.
important meeting? Like you have a lot of important meetings with your company. What if she decided, says to them, oh, I'm going to take my sick leave now?
You mean like 5 minutes before the meeting?
Well, no, day before.
Yeah.
Oh, you know that important meeting you have next Tuesday?
It's tricky.
taking
It's
that.
tricky. I mean, an employer can have reasonable parameters around this, right? You know, I'm sort of speculating at this point because the state law is so new, there haven't really been cases explaining it. But I would imagine that if you're scheduling a routine medical appointment for your child, your employer could make reasonable requests of you about when you did that.
Yeah.
If you're sick, and you can't really do anything about that.
Interesting.
Yeah, but it is tricky. So let's say Camille was sick right before a meeting and her boss was very upset by that and it caused a huge problem in the company. It would be very dangerous territory for them to discipline her for that because it might be retaliation for using her sick time.
Have you taken any of your sick leave?
No.
You never take sick leave.
No, because I don't, fortunately, I haven't really been sick, but since I work from my home a lot of times,
You can be sick at home.
I can still work from home even though I'm not feeling my best.
Oh, that's
And plus,
interesting.
it's a big company, so
Yeah.
even if I said an hour before that an emergency came up, my manager or someone else could always fill in immediately because we all kind of know what each other is doing. But in other cases, that may not be true.
Oh, I know what I was going to ask you. Is that, I forget the word, but build-upable? You could save your sick time and then take a few weeks off?
You can save it up to 40 hours,
Oh.
but you can't use it like a personal day. In other words,
It's not a use it or lose it.
It is.
Oh, it
You build
is?
up to 40 a year. The employer can decide whether to carry it, kind of like vacation. It's up to the employer.
What about a
whether they-
mental health day when you say you can't use it as a personal day? Suppose you say, well, I just have been so stressed out, I have to have a day to myself where I don't have any commitments.
I suspect you could get away with that. Going to the beach might be tough.
I just
She
needed
goes
to
the
be at the beach.
a lot, too.
Yeah.
But here's the kind of employee this really fills a gap for is a working mother at a lower wage, less autonomous
Yeah.
job who previously could get in trouble for, taking care of a sick kid, taking kids to doctors. That gives a little bit of a buffer
Sure.
for that population.
What about non-compete agreements? That's kind of an interesting one.
Those are fun.
Yeah.
Those are fun. Yep, so Massachusetts recognizes non-compete agreements, and to translate for anybody, those are agreements that you're frequently asked to sign when you start a job that says when you leave here, you will not compete with us for 6 months, a year, 2 years. They're all over the map.
What do they mean by compete?
It depends.
Oh, okay.
It has to be reasonable.
It
Isn't
has
that
to be
the word,
reasonable, right.
reasonable?
So Massachusetts will recognize them, but they will only enforce them if they're necessary to protect a legitimate interest of the company. And to a layman, it might be legitimate for a company just to want to push the competition aside, but that doesn't count. It has to be about trade secrets or goodwill. Like if you're a salesperson who's built a bunch of relationships for the company, that's the kind of goodwill that you can protect with a non-compete.
Okay.
Somebody sent me an email when they heard you would be on. They said ask, they had a thing where a non-compete, they said ask if you can say anything about cease and desist letters. In other words, your employee went, they opened it up,
Yeah.
you feel they opened it up to their business too close to you or whatever on the internet or this or that, and they don't, so they're saying, well, send a cease and desist letter. I said, well, you might have to show that it, do you have to show that it ruined your business? I mean, that it took away your business first before you do that?
No, it's a great question. So cease and desist letters are just letters. You know, they're a shot across the bow. So sometimes it's helpful. Sometimes if you're the person who wants to enforce the non-compete, sometimes they're worth doing just to get on record really quickly that you're worried about this and you want them to stop. But nobody has to respond to a cease and desist letter. What the company has to do is go to court and get a preliminary injunction. And to your question, what that means, they don't have to show that they've already lost the business. They have to show that it's likely that they're going to.
Oh, it's likely. But
but
it wouldn't hurt
sometimes
for them
it's-
to write a letter, like a 93A letter.
Yeah,
They write them a letter?
Yep, it doesn't hurt. It doesn't hurt. But I think sometimes people who get those also don't understand they don't have any legal significance. You know, people will get a cease and desist saying, you must respond within 15 days. Well, they just said that. You know, until somebody files in court and actually triggers the rules and the schedule.
That would be a superior court as opposed to a district court.
Probably, because they'd be seeking equitable relief.
Oh, that's interesting.
Yeah.
That's interesting.
So, and non-competes, I mean, they make a lot of sense in certain places and for certain levels of people. I think sometimes employers either go overboard or somebody just hands them something off the internet and says, hey, I heard it was a good idea to have a non-compete. And so you might have somebody making Subway sandwiches under a non-compete.
Well, let's take an example, like you're in a law firm, let's say, and of course that's pertinent to you. So let's say you've been working for a law firm, a large firm or something, and in Boston, and let's say you decide that you want to go off on your own, so you start your own practice. Would that be something that could be subject to a non-compete if they had?
So not here.
No.
Not here. And you could say it's because a lot of the legislatures who write the laws are lawyers, but lawyers aren't subject to non-competes.
Oh, okay.
Nor are doctors. There is a theory
I
behind it,
see.
which is
Okay.
that the patient or the client, the consumer, should have an unfettered right to the professional assistance of their choice.
Okay.
So they
Well,
don't apply to
maybe
those.
another profession.
Yeah,
let's
They,
say.
different
don't
profession.
apply to lawyers, even in a big firm?
If
Oh,
you,
that's interesting. I didn't realize that.
well, in my profession, let's say you have an insurance agency
Yeah.
on Main Street, and it's a big one, and so then someone there, an insurance agent, decides after years to go off and start his or her own agency, and it's in close enough that you could say it's going to provide competition. Is that something that the first employer could have set a non-compete
Maybe.
agreement?
And it happens all the time, by the way, in that industry in particular.
Really?
If you set up shop next door to your old employer and you have none of their confidential information and you have no relationships with their customers, you know, a court may not enforce that. An insurance agent, however, spends a lot of time with the customers of the firm. So most likely, if it was otherwise reasonable, a court would enforce that because you're taking your employer's goodwill next door and hanging a new sign in front of it.
Hairstylists have that a lot too, where if somebody
Oh,
leaves and
yeah.
goes to another salon or goes on their own,
They do.
a lot of times they say, well, I can't tell you where I'm going to be.
Well, that's a great example because, you know, people ask sometimes, well, like, what's reasonable? How much time? How much distance? And it really depends. So for hairstylists, it's usually a 2 to 5 mile radius.
Oh,
Whereas if you're an insurance agent, your non-compete might cover the whole state or cover the whole
I think
New
a lot of
England region.
hairstylists, they'll pay for their space. So that would let them go down the street and just take their people
Yep.
with them.
Yeah.
Then it comes to whether they take one of the other people with them that they shouldn't have. But a lot of times you have to look at it practically. Is it worth it to sue? It depends.
Yeah. It depends. I think sometimes there's emotion in it.
Yeah, sure.
You know, sometimes I've certainly seen employers spend more money than it was worth pursuing non-competes. But sometimes they feel very strongly that they need to set an example.
Yeah, they probably do. It depends if they
Yeah.
have 20 other people waiting to see what's happening, so they can do it too.
Right. Well, and a lot of times, I mean, we see this a lot with people who come to us. They're thinking about leaving a job and they've got a non-compete. A lot of times they're written really broadly, but there's a much smaller subset of things the employer really cares about. So a lot of times you can get out in front of it and call the employer and say, hey, they want to do X, Y, and Z.
Yeah. Well, I know of a situation that happened not long ago where someone working for a very large company in the health insurance business and has been in this business, this person has been in the business for quite a while, even before working at this company. And so he decided to leave the company and could very well go back and start his own business again. And but he told me recently, he said, I have to figure out the nature of what's included in the non-compete to see if I really can do that, or if, because there aren't many that do this particular
Yeah.
kind of a service, so
Right.
there are possibilities that could impede it.
There could, you know, the other thing that it's so tough with non-competes because for everything that I could say about them, there's a case that says what I said and there's a different case that says the opposite, but there is some authority to say that if your job changes significantly before you quit, then you don't get to enforce the old non-compete on the theory that you created a new employment relationship.
Oh, that's interesting.
Yeah.
We've had cases where employees subject to non-competes weren't paid properly what they were supposed to be paid. That can knock out a non-compete.
Yeah.
So there's a whole bunch of stuff that
Yeah.
people need to think about.
Do you have any cases that you can share with us?
Let's see, I can share without divulging industries or individuals. And we had some clients who were sued for violation of their non-compete agreement, and in the end, they were released from the non-compete, and their employer had to pay them like $80,000.
Really?
Yeah, because they were owed
Wow.
money under the Wage Act.
Tell us about that.
Yeah.
I want to not get into too many details because it might be identifying.
Oh, no, I don't
but-
mean in that particular
yeah.
case, but just
Oh.
in general, the Wage Act
Yeah.
and how, let's say you're doing, someone's doing a job and they're asked to do another job, but they find out somehow or other that other people doing that job are being paid more.
Yeah.
How would what kind of rights would they have,
Yeah.
especially when it relates to this, the non-compete?
So generally, the unequal pay you don't have a lot of legs there unless it's a gender issue because there's a federal Equal Pay Act. But the way the Wage Act works is initially it's just to say you got to pay the wages within a certain amount of time. That's pretty simple. If you've got an hourly employee, pay them within 6 days of the pay period, pay them no less frequently than every 2 weeks. Where people get into trouble is with commission-based employees, because commissions are also subject to the Wage Act, but there's a lot of room for argument about when they're earned, when they should be paid. So that overlaps with the non-competes a lot, because salespeople are frequently under non-competes, salespeople are frequently working under ambiguous commission structures.
Oh, sure. Well, if you have, just independent of non-competes, if you have employees working and they're doing pretty much the same job, is the employer required to keep make sure that the wages are
Keep it equal?
equal?
Only if they're unequal based on gender.
Really?
I mean, let me back up. There's a specific Equal Pay Act that's about gender. There's all the anti-discrimination laws that are about everything
Any
else.
gender or the new gender?
Interesting question. I mean, the Federal Equal Pay Act is meant to protect women in the workplace. I've never gone back and looked to see if it would require amending to apply to transgender
Yeah, that's
or
interesting.
any other sort of identification. But the discrimination laws, if you're paying two people for the same job differently and one of them is in a protected class and the other isn't, then you always have a risk of a discrimination suit. And
When you say a protected versus unprotected class, what do you
Yep.
mean?
So the discrimination laws define the protected class are those people who are protected by discrimination laws. So you can't discriminate based on gender, you can't discriminate based on race, you can't discriminate based on national origin, disability, religion, color. And then in Massachusetts, though not at the moment under federal law, you can't discriminate based on sexual orientation or gender identity.
How about disturbing habits?
No.
Maybe somebody clicks away at something or chews gum. That's another thing. Can employers impose dress codes or to be clear shaving or no tattoos or things like that?
Yep.
Or no nose rings and everything? They can do that?
As long as it's not a dress code that, unfairly singles out one of these classes.
So if you tell somebody, I don't want you coming with that nose ring and those type of clothes here anymore, and they don't do it, and then they start doing it again, that's
For the most
grounds for
part.
dismissal?
For the most part, you can do that.
That's interesting.
How about, this is an interesting one, age discrimination?
Yes.
When it comes to termination or even
Yep.
being overlooked for a position?
Yep.
Because that's a hard thing to prove, isn't it?
It's a hard thing to prove. It's super common. And interestingly, the cutoff, the protected class begins at 40, which was established years and years and years ago. And sort of with the baby boomer generation aging, and 40's not that old in the
No, it
workplace
isn't,
anymore. So, it'd be interesting to see if that ever changes.
Well,
But-
it happens a lot now. It's been going on for a while where there might be a cut, cutting back on employee staff, and a lot of times it could be that some of the older ones were tapped on the shoulder.
We've found that a lot of older people, that Social Security is not enough to live on, so they're out looking for jobs now.
Yeah.
So you'll see people over 65 looking for jobs.
Sure, yeah, because they can't live just on
which is-
Social Security.
Which is interesting.
Right, and it's tough because there's a bunch of things that could be just code for age discrimination that are also just facts. Like if somebody's been at a job for 30 years, their pay is higher. And employers do get to make decisions about economics.
Sure.
If
Yeah.
somebody's 75 years old, they may not be as versed in the digital world as people. So
Yeah.
it happens.
You're not kidding either.
and
We're
there are
into You've Got to Be
biases.
Kidding. Would you believe it? We're in You've Got to Be Kidding.
We are.
I have a story for You've Got to Be Kidding, and
Excellent.
see what you think about this, except it's not employment. I won't mention names either, but we bought a new computer in November, the end of November, and paid about $1,300 for it. And then we got the extended plan. In today's world, that's a lot for a computer. A lemon from day one. Anyway, we finally gave up on it the other day after spending almost 8 hours with the technical support of the manufacturer. They finally couldn't do anything. They did this. They put new motherboards and everything. Forget about it. Microsoft got in the picture. It was even worse. It wasn't even a thing. I said, I'm taking it back. I can't stand it. Just locked up. It's a good name, but I must have just got a lemon. We bring it back to the place, and unbeknownst that this is a place that I've heard people say they've brought mattresses back after 8 years. They'll take anything back. Anyway, oh no, there's a sign there, no electronics after 90 days. I says, well, what do I do? Well, call back the manufacturer again, and then they have a service, call them back, but we can't take the computer back, credit, nothing. And we buy a lot of stuff there. Anyway, I get a hold of Dell again, and they go, well, we can't exchange. Oops, I said that. It doesn't matter. Anyway, they're a good company.
Yeah.
We have other ones. They said, we can't exchange computers. We just service them. We can just service them. The extended warranty, there's a warranty on it. I called back the concierge there. They can't do anything either. They just advise you how to set it up. Call the extra warranty place. But for people who are out there, the square trade, I'm sure everybody has some extra warranty. Try to get into the website or phone.
No.
Try it. You go,
What happened?
I can't seem to get anywhere. And they don't have my, I don't have the right password, or I did have the right password, or they don't show that particular computer. So, I mean, it's going to be another thing. So frustrating. I mean, and I know as an attorney, I'm entitled to a product that works.
Yes.
It's like 4 months, and I got this lemon, and if I don't have the, and I know what the other people are going to say, well, we probably won't do anything if Dell already did something to it. I think I'm going to be going around the circle, or maybe I won't.
That's why they
Tune
wrote.
in to see what happens.
That's why they wrote Chapter 93A.
Yeah,
Because you don't go after people if it's only worth $1,300, but a breach of warranty is a violation. And
But
it's the
isn't that
patron's fees.
frustrating?
That is
Extremely
It's so
frustrating.
frustrating. You know, you try to do something on the computer and it locks up, and then it locks up, and then it locks up again, and it's, hey, you're supposed to say you've got to be kidding.
You've got to be kidding.
No,
You're not.
no.
I know
Oh,
that.
this is my you've got to be kidding bag. Now, here's the you've got to be kidding bag, and these are all the different things, but I did ask for that comment that you made. There goes, this is a story. You've got to be kidding, falling down there. Oh, the only thing, we got more books coming. The activity coloring book is doing well. We'll be delivering Billerica. We just finished Holbrook. We're waiting for that,
And,
that'll be printed.
Weston too, is that?
Weston was delivered,
Fantastic.
and you know it's funny. They all have. This is one of my favorite, the Buzzards Bay one with the
Oh, yeah,
minions.
I saw that.
How many do we have now? How many towns? Police department?
25.
Fantastic.
Plus out of states inquiring. But what's interesting, the police all say the same thing, no matter whether they're from a big town or a small town. They want the parents to stop telling the kids if they're bad, they'll call the police on them.
Yes.
The police officers are their friends, because then if a kid gets lost and he sees a police officer, he'll be afraid, oh, well, he's not there. So it's these books are to teach at a young age that police officers are our friends, and they're a great group of guys out there. And we want to thank Emily, and Camille will wrap it up. This book is so good. Anybody that wants it,
And it's a
tell
nice,
them.
quick read. That's the best thing about it.
And I can leave you guys with a stack, so if anybody
Oh, good.
listening
Yeah, I got people
emails
that
you,
already want
Yes,
it.
if anyone would like a copy of the book, just send us an email, and we'll be happy to share that with you. And in the meantime, we want to thank Emily again for ingratiating us with her presence and her knowledge.
Thank you very much.
And for our viewers, we thank you so much for watching, and we encourage you to send us an email if there's any topics you're interested in, or if you have any questions or feedback. We need to hear from you, because remember, this is your show, the law, your money, and you.